All right. So our next panel is on the AWA's interaction with other laws, and it's going to be moderated by Varu Chilakamari from the U.S. Department of Justice and their Animal Welfare Enforcement Division. So here you go. I hand it over to Varu.
Well, thank you, everybody. So I'm really pleased to be able to moderate this panel today. Panel 2 is entitled The Animal Welfare Act and its Intersection with Other Laws, Interaction with Other Laws. We have on our panel today Ani Satz, who is a professor of law from Emory University, and Delcy, who has been introduced already numerous times today. So very briefly, Ani is going to talk about the intersection of the AWA with state laws. And so specifically, she'll talk about the preemptive or the perceived preemptive effect of the Animal Welfare Act on state anti-cruelty laws. And Delcy will be talking about how this occurs on the federal level, and specifically the interaction of the AWA with another federal law, the Endangered Species Act, and how those two laws apply to captive animals. So animals that are both listed as threatened or endangered under the ESA, but are also being held in captivity by zoos and the like, and how those two laws apply. So with that, I will turn it over to Ani.
Good morning. I will be speaking about animal protection and the myth of Animal Welfare Act preemption. And my main argument is that the myth of Animal Welfare Act preemption undermines protection of animals covered by the Animal Welfare Act against cruelty, and that the USDA or its subagency, APHIS, should either issue a policy statement or regulations clarifying that the AWA does not preempt state law targeting animal cruelty. And my presentation will have three parts. First, I'd like to talk about the myth of AWA preemption. I'd then like to talk about judicial stories supporting that myth. And third, I'll talk about implications for animal...
I don't want people to be distracted.
Okay, should I stop?
Sorry about that.
Should I start over? Just keep going. Okay.
Sorry about that.
Don't hold that against me. So my presentation will be in three parts. I'll talk about the myth, I'll talk about judicial stories supporting the myth, and I'll talk about implications for animal protection if the myth of AWA preemption is overcome. First, with respect to the myth. Anecdotally, preemption is one of the biggest challenges identified by lawyers litigating cruelty cases under state laws on behalf of animals covered by the AWA. In fact, some lawyers with whom I've spoken believe preemption is an impediment second only to the well-known standing issues that plague animal activists in litigation. The challenges posed by preemption are puzzling for a few reasons. First, they are supported by limited case law. There's only a handful of cases from the Fourth Circuit and the state courts of California, Maryland, North Carolina, and Pennsylvania, and there is some conflict within the state courts of North Carolina and Pennsylvania that support preemption. About 20 other jurisdictions do not find preemption. Second, the plain language of the AWA expressly permits states to enact laws pertaining to animal cruelty. Section 2145B, which is in the original 1966 Act as Section 15B, states, the Secretary is authorized to cooperate with the officials of various states or political subdivisions thereof in carrying out the purposes of this chapter and of any state, local, or municipal legislation or ordinance on the same subject. Section 2143, which was amended in 1985 as part of the Improved Standards for Laboratory Animals Act, expanded, or some might argue perhaps clarified or tried to clarify any confusion on the preemption issue by stating the AWA shall not prohibit any state for a political subdivision of such state from promulgating standards in addition to those standards promulgated by the Secretary. So the timing and placement of that 1985 amendment is quite interesting, or addition, because it seems to indicate the USDA felt that there was, in fact, some confusion. And it happens to be in an amendment that largely supports improvement of protections for laboratory animals, so they seem to anticipate some confusion about whether state standards would apply. And the legislative history supports that. Legislative testimony ranges from people saying, well, hey, we already know that there's no preemption, to saying, oh, this would add preemption, and that's a problem. So the hope was in 1985 it would be clarified. The myth is also perplexing because, third, there's a general preemption in that federal law does not preempt state law. States have reserved powers under the 10th Amendment to protect the health, safety, and welfare of their citizens, and animal welfare is recognized as falling within that power, given the relevance of animal welfare to things like human illness, food production, and domestic violence. And in fact, we know federal law preempts state law only in 3 circumstances: when Congress explicitly states so, express preemption, implicitly indicates an intention to preempt an entire field of law, field preemption, or state law conflicts with federal law, conflict preemption. And in fact, states address animal cruelty directly and indirectly. All 50 states, the District of Columbia, and US territories have anti-cruelty statutes, and a few states also have statutes that may facilitate the litigation of anti-cruelty claims through private litigation, such as statutes that protect taxpayers against illegal or wasteful use of funds. So you may be saying, okay, fine, there's a little confusion over preemption, but who cares? Well, it turns out that the myth of preemption is problematic for a number of reasons. First, it's an inaccurate interpretation of the law, arguably disrupting the function of the law. Congress did not intend to preempt and even encouraged in 2145 to develop state laws, even encouraged cooperation to develop state laws protecting animals covered by the AWA. Second, and most importantly, it undermines protections for animals covered by the AWA. The states often have stronger protections. We know the AWA has minimum coverage, and there are a lot of well-known exceptions, including exceptions for anesthesia not being required when it interferes with experimental results. And just personally, I feel the most important aspect that's lacking from the AWA is that the statute does not intend and fails to address the question of what suffering, psychological and physical, is ever justified. And this is something that state statutes come much closer to doing, and some would argue are successful in doing, in terms of defining instances of abuse, neglect, and torture. Third, this myth of preemption has a possible chilling effect on district and other government attorneys from bringing cases that affect animals covered by the AWA. There's a lot of anecdotal evidence, including one example from the Massachusetts Attorney General's office, who declined to prosecute a Northeastern University professor for fighting hamsters in violation of state anti-cruelty statutes because the research is largely covered by the AWA. And this is of concern, of course, because many believe the AWA has restricted enforcement. As of March 2016, APHIS was overseeing 7,435 licenses and employing only 112 inspectors, which is now down to 104. And data through mid-year indicates only 104 cases initiated, resulting in 74 warnings, 15 settlements, 9 administrative law decisions, and nearly 51,000 approximately in civil penalties, which for many of these large operations is pocket change. I'd like to now move to the second part of my presentation, which is about stories told by judges supporting the myth of AWA preemption. And for the sake of time, I'm going to focus on animal research. The stories may be divided into 3 broad categories: stories that could support field preemption, stories that could support conflict preemption, and what I am calling in very technical terms, a grab bag. Conflict preemption, that is really only coming from one case, but there are a number of cases that interpret or have different stories that could support field preemption, and I'm just going to list them here. I don't have time to go into them right now, but federal oversight through both the AWA and federal grant requirements has been used as an argument to support something like field preemption. The, quote, delicate balance argument of promoting use of animals and protecting them, which is the argument on which I will focus, the equitable abstention doctrine, which hails largely from California case law and is applied in complex policy matters involving equitable relief when a regulatory agency has primary enforcement authority. All of those are arguments that have been used to support something like field preemption. And then the classic grab bag of agency discretion, fear of judicial activism, efficiency, and fairness. And ironically, the courts that do argue that there is preemption by the AWA, for the most part, do not actually apply preemption doctrine. They're applying these other arguments that are preemption light, or whatever you want to call them, to try to get at something like preemption. And I would say that this contributes to this macro level, to the myth of AWA preemption in a very nefarious way, because it generates the spirit of preemption in animal cruelty cases, so people feel it. It feels like it should be preemption, but it has no doctrinal hold. So I'm going to focus on the delicate balance argument, and my stopwatch has stopped, just so you know, so I don't know if it knows. I could go all day. The basic argument is that the USDA must uphold a, quote, delicate balance between animal welfare and scientific progress, and it will be disrupted if anyone from outside the agency enforces the humane treatment of animals. And I believe that this argument may be broken down into several parts. And this is my interpretation, this is my interpretation of the case law, and not from the courts. Scientific autonomy seems to be underlying this claim, and although free speech is not raised by the courts, I think it certainly could be. Scientific progress, standing to sue, agency discretion, and agency bias. And unfortunately, these different parts are often conflated and unexplained in cases, marshaling the delicate balance argument. And what I'm going to do is, it turns out it's very complex. There's sort of a vague sense of preemption, and then they're making complicated arguments even within that vague attempt to establish field preemption. I'm going to focus just on the scientific autonomy part of the delicate balance argument. Okay, that's how complicated I think it can be. The autonomy component of the delicate balance argument is first advanced in a case from the Fourth Circuit, and this is an older case, 1986, called International Primate Protection League. Here the court discusses the minimal standard for care for primates under the Animal Welfare Act, and how that should not, and there should not be any, how animal welfare in general should not interfere with medical research and researchers' autonomy. The court cites the congressional record and states that under the AWA, quote, a research scientist still holds the key to the laboratory door. A more extensive discussion of all aspects of the delicate balance argument, including scientific autonomy, appears in Salk v. Regents of University of California, a more recent case from 2008, which involved taxpayers suing under the Code of Civil Procedure 526A, which allows citizen suits for illegal or wrongful use of public funds for declaratory and injunctive relief for AWA violations. The court held the action is preempted and the enforcement of the AWA is discretionary. The appellate court affirmed by holding that the Salk action constitutes a sufficient obstacle to department enforcement of the AWA to warrant the application of federal preemption. And again, they cite the same laboratory key language that we saw in international primate protection. Now, I think one can identify several problems with the autonomy component of the delicate balance argument, which really is the primary component of that argument for something like field preemption. To start, the court confuses autonomy and process with outcome. Scientific autonomy does not necessarily equate with scientific progress or clinically useful findings. Presumably, the delicate balance argument actually refers to the goal of medical research of benefiting patients, not scientific autonomy in itself. Unfettered scientific experimentation certainly need not result in useful clinical application, as I think history has painfully shown. The court provides no evidence that scientific autonomy to experiment on animals fosters better research outcomes, or that alternative models could not be used, only that medical research generally, allegedly, supports clinical advances. Next, the court assumes without proof that the USDA's enforcement of the AWA will not interfere with scientific autonomy. So yes, I'm saying they are not being fair to the USDA here. Obviously, this certainly need not be the case, as the USDA's recent $3.5 million settlement against Santa Cruz Biotechnology indicates. Lastly, the argument presented by the court is not one of balance between animal and research interests at all, which in itself I would argue is a false conflict, but one that tips the balance in favor of the researcher. International Primate Protection League and SALC both assume acceptable agency bias towards medical research. I think that's clear, right? They're holding the key to the laboratory door. While the ontology of this argument is unclear, it may stem from the fact that the USDA is the only government agency without a stated neutral mission. Wow. And they apparently control the lights. It exists in part to advance the interests of agribusiness. So I think it is not a far step to argue that it also supports the use of animal bodies in other contexts. The argument also reflects entrenched interest convergence in the regulation of human uses of animals. That is, laws afford protections to animals only when doing so does not conflict with human uses of animals. So to summarize, let's turn this on. If we are able to move beyond the myth, and this was my implications part, and to clarify the preemption question, it would reinstate state and local rights in this area and restore the function of state and federal laws. And I believe this could have a profound effect on the prevention of animal cruelty on a number of fronts. I will just briefly mention, just list 3 reasons for you. First, it would allow courts to create precedent of federal-state cooperation in the crusade against animal cruelty. Settlements often involve no admission of fault and undisclosed details. Second, it would overcome the de facto position of preemption, especially in the context of animal experimentation where little case law exists. And third, it would mitigate any chilling effect on district and other government attorneys and animal advocates from bringing cruelty cases. Thank you.
Oh, no, you're kidding me. Oh, yeah. I just noticed that. Let's see here. Bear with us 1 second. Let me just go grab some.
I can go ahead and start so we don't get too far behind. I think the slides are more important for the latter part of my presentation, so I'll do that. And I promise I'm not involved on every single panel, so you guys won't see more of me today. As Baru said, I'm going to be talking about the interaction between the Endangered Species Act and the Animal Welfare Act, and I'll be talking about how these 2 laws operate or should operate in tandem. So I'm going to give a very brief and vastly oversimplified background of the Endangered Species Act, and then talk about a key prohibition when we're talking about captive wildlife, which is the prohibition on quote-unquote harassing animals. And as we'll see, animals at Animal Welfare Act regulated facilities who are also listed under the Endangered Species Act are supposed to be protected against harassment, but in fact, often are not. So the Endangered Species Act was enacted in 1973. The Supreme Court has described it as, quote, the most comprehensive legislation for the preservation of endangered species ever enacted by any nation. And it imposes very strict limitations on what you can do with listed animals, members of listed species. And with very few exceptions, those limits apply to both wild animals and their captive counterparts. And Anna, during the last panel, suggested some of the reasons underlying this, and they include the fact that captive breeding practices have impacts on the species as a whole, particularly genetic integrity. The uses of captive animals can also drive markets for poaching and other harmful uses of wild animals. We're also learning more and more about how human interactions with captive wildlife can affect conservation efforts. So just a few examples. Studies are showing us now that allowing the public to interact with dangerous wild animals increases demand for those animals as so-called pets, and that in turn can increase demand for pulling them out of the wild. And we're also learning that seeing humans in close contact with captive wildlife can have serious impacts on people. So a number of studies coming out of the Lincoln Park Zoo have shown that seeing those kinds of interactions can make people believe that the populations are more stable and healthy, and can also make them less likely to donate to conservation. I'll pause so we're not too distracted. Thanks.
Okay, we're not getting, there we go. Great. You can just start.
I'll take my notes.
That old trick.
Thanks. Sorry about that. Thanks for bearing with us. So captive animals who belong to protected species can and should be regulated under both the Animal Welfare Act and the Endangered Species Act. One of the reasons that this is so significant for advocates is that the Endangered Species Act, unlike the Animal Welfare Act, which we'll hear about tomorrow, has a citizen suit provision. So it allows any person to bring suit to enjoin violations. And there are limits on that, of course, like you still need to have standing, but it is a very broad grant. So what kinds of things might be challenged in a citizen suit? One of the main ways the ESA protects endangered animals is by prohibiting a host of activities with them. Most notably for our purposes today, a prohibition on take. And take is defined to include a host of things, including harassing, harming, pursuing, hunting, shooting, wounding, etc. And the Supreme Court has noted that reports from both the Senate and the House committees at the time the statute was passed made very clear that the take prohibition is supposed to be very broad. So the Senate said take should be defined, quote, in the broadest possible manner to include every conceivable way in which a person can take or attempt to take fish or wildlife. The House similarly noted that the, quote, broadest possible terms were used to define take. The House also went on to note that this is so broad it could even reach, as an example, the activities of bird watchers, if those might disturb the birds. So what does this mean for captive animals? None of these terms that you see within the definition of take are defined by statute. Some of them are defined by regulation. So harm is defined by both the U.S. Fish and Wildlife and the National Marine Fisheries Service, the two agencies with primary enforcement responsibility, as an act which actually kills or injures fish or wildlife. And it then goes on to give some examples of what those activities might be, a non-exclusive list. So as you can see, to harm an animal under the regulation, you need an actual injury or death. And that can certainly arise for captive wildlife, but ideally we would stop the problem before it actually reached the level of actual injury or actual death to an animal. So enter the harassment prohibition. Harassment is not defined by the National Marine Fisheries Service. The U.S. Fish and Wildlife does have a regulatory definition of the term. So here you can see it's defined by regulation as, quote, an intentional or negligent act or omission which creates the likelihood of injury to wildlife by annoying it to such an extent as to significantly disrupt normal behavioral patterns. And again, it gives examples: breeding, feeding, sheltering, non-exclusive list. The definition goes on, however, to have an exception, to specifically exempt from the definition, quote, when we're talking about captive wildlife, generally accepted activities, including, most notably for our purposes, the first item, animal husbandry practices that meet or exceed the minimum standards for facilities and care under the Animal Welfare Act. So why did Fish and Wildlife put this regulatory exception in place? Basically, the agency saw a tension between the fact that the Endangered Species Act doesn't prohibit the mere possession of wildlife. They don't prohibit you from keeping wildlife, but they prohibit you from harassing that wildlife. And arguably, keeping a wild animal in captivity, just the mere fact of keeping them could be considered harassment. And so Fish and Wildlife was trying to strike a balance between the fact that possession was allowed, harassment was not. And this was their attempt to do this. But at the time they promulgated this regulation, they made very clear that this is meant to exempt proper, humane, healthful animal care, but that, quote, improper husbandry and keeping animals in, quote, inadequate, unsafe, or unsanitary conditions, physical mistreatment, and the like constitute harassment because such conditions might create the likelihood of injury or sickness. So this is not a blanket exception. So how does this play out for captive animals in reality? In terms of enforcement, I was not able to find a single instance of a federal prosecution for harassment of captive wildlife. We do see prosecutions pertaining to captive animals who are trafficked, but generally not for the conditions of their captivity, although Baru may tell me that I'm wrong about that, but I haven't seen any such cases. We are seeing more and more citizen suits challenging harassment of protected animals, and I'm going to talk about 3 recent cases where this has come up, and all 3 of these cases are currently pending in federal courts of appeals. And each of these cases has significant outcome, not just for the plaintiffs in those cases and the animals at issue in those cases, but really for the future of the Endangered Species Act's application for captive wildlife going forward. So for that reason, I'm going to focus the rest of the discussion on those cases. So the first involves Lolita, who Naomi and Georgia talked about a little bit before. Lolita, as you heard, is at the Miami Seaquarium. She's in the smallest orca tank in North America, which has this obstruction in it. Just a little bit more background. About almost 50 years ago, Lolita was taken from her pod in the Puget Sound as a baby. As you've heard and probably already knew, orcas are highly social animals, but Lolita has not seen another orca since 1980, when her companion, Hugo, rammed his head into the side of their tank, which many believe was a deliberate act of suicide. Despite the fact that Lolita has not seen another orca for decades, it's reported that she still uses vocalizations that are known only to her pod. And reportedly, when she was played a recording of her pod's calls, she even responded to and returned those calls. As you heard from Dr. Rose, wild orcas swim tremendous distances. They can swim up to 100 miles a day. They dive hundreds of feet. Lolita is 20 feet long. Her tank is 20 feet at its deepest, and it's 80 feet across at its widest. So it's impossible for her to dive even a few feet. It's impossible for her to travel any meaningful distance. So this is even smaller than that SeaWorld tank that we saw during the earlier presentation. So what does the Endangered Species Act have to do with this? In 2005, the National Marine Fisheries Service listed the population of orcas that Lolita was taken from, the southern resident killer whale population, as endangered under the Endangered Species Act. But when they did that, they excluded Lolita. They excluded captive members of the population. Lolita was the only one. They gave no explanation whatsoever for doing that. So a coalition of groups then challenged that and ultimately were successful. Last year, finally, 10 years after the initial listing, Lolita was included in the listing, and shortly thereafter, an Endangered Species Act citizen suit brought again by coalition was filed on her behalf, contending that she was unlawfully being harmed and harassed in violation of the Endangered Species Act. The district court in that case, despite recognizing that Lolita's conditions were disrupting her normal behavior patterns, concluded that they don't violate the Endangered Species Act. So among other findings that the court specifically made were that Lolita lacks social contact, Lolita engages in abnormal stereotypic behaviors that are well-recognized signs of poor welfare, and, quote, from the court's opinion, Lolita cannot engage in normal swimming or diving behaviors even as compared with other orcas in captivity, causing her physical and psychological injury. The court then went on to say, quote, in a literal sense, these conditions and injuries are within the ambit of the ordinary meaning of harass. But the court denied relief to Lolita. What the court said was, an Animal Welfare Act licensed exhibitor takes a captive animal in violation of the Endangered Species Act only when its conduct gravely threatens or has the potential to gravely threaten the animal's survival. So this requirement of a grave threat is certainly not in the regulatory definition. It really has no basis in the law. It flies in the face of the Supreme Court's recognition that Congress intended the take prohibition to be interpreted very broadly. And this also impermissibly treats captive animals differently from their wild counterparts. So this decision is on appeal before the 11th Circuit. Full disclosure, I'll be arguing that case, so you know my point of view on the issue. And the stakes are really high, not just for Lolita, but for all captive animals. The second case was brought against the Cherokee Bear Zoo. It was brought by two elders of the Eastern Band of Cherokee Indians against a roadside zoo in North Carolina that confines 4 grizzly bears to virtually barren concrete pits. Thank you. And the district court here recognized that confining bears to pits, also taking their babies away, which is a routine practice, is, quote, archaic, is advised against by experts, is harmful to the well-being. But because the USDA has tolerated these conditions under the Animal Welfare Act, the court found no violation of the ESA. So the court completely disregarded the requirement that to be exempt from the harassment prohibition, an activity needs to be, quote, generally accepted. And so what the court said is whether CBZ's practices are generally accepted is not relevant. Only when the exhibitor's practices fail to meet the minimum standards established by the Animal Welfare Act can such practices constitute harassment of captive, endangered, or threatened species. This is guts protection of the Endangered Species Act for captive animals if it's upheld. And again, stakes are very high. This was set for oral argument in the 4th Circuit for January. That's just been continued. We don't know why, but that'll be heard early next year, like Lolita's case. The final case involves a Cricket Hollow Zoo, and this is a bit of a happier story, at least so far. So Cricket Hollow is a roadside zoo in, or was, I should say, in Iowa. And a lawsuit brought by Animal Legal Defense Fund and 5 individuals challenged their treatment of endangered tigers and lemurs, challenging things like social isolation, inadequate vet care, inadequate sanitation. And the district court held that lemurs and tigers were indeed being treated in violation of the take prohibition of the Endangered Species Act. Among other things, the violative conditions were keeping lemurs, which are highly social animals, without adequate social enrichment. So Lucy, the red-ruffed lemur, who you can see here, she was kept completely by herself, despite the fact that this is a highly social species. Tigers were kept in filthy enclosures with excessive built-up feces and denied veterinary care. The court noted that in just over 2 years, 5 tigers had died at the facility, including Casper, the tiger who you can see there. But, of course, the zoo is appealing the case, and that's now pending in the 8th Circuit. And among other things, they argue the mere fact that Cricket Hollow is licensed by the USDA under the Animal Welfare Act should render it completely exempt from the ESA's take prohibition. And here's a few quotes from their appeal. Sorry, I'm skipping that. The Animal Welfare Act provides a safe harbor for licensed facilities. As a licensed facility, they were exempt from the Endangered Species Act as to the animals they exhibited. They cannot be subject to any liability under the ESA because it's an exhibitor under the Animal Welfare Act, and there's no private Endangered Species Act action against a licensed facility. These are really extreme arguments. These go further than the district courts that we saw in the other 2 cases, and I hope the court will see through these, but again, we need to make sure that they do. Thank you. So we have 3 cases, really high stakes, pending on appeal. And I just briefly want to note another effort that's pending on this issue. So the Humane Society of the United States last year filed a omnibus petition for rulemaking to the U.S. Fish and Wildlife Service on issues pertaining to captive animals under the Endangered Species Act. Anna Frostic, who you heard from before, drafted that. It's a really great petition, and among many other things, it addresses this harass definition and urges Fish and Wildlife to amend the regulatory definition of harassment to completely get rid of that exception that we saw. So Fish and Wildlife has not yet formally responded to that. I'm hopeful that they will, and that in the interim, HSUS will hold their feet to the fire. But I think that regulatory fix could also help provide guidance to the courts as these cases continue to arise. Thank you.
Thank you. Those were lovely presentations. I will start off with a couple of questions, but please, folks from the audience, start writing them down on your note cards. So I think a common thread in both of your themes was having a more limited view of the Animal Welfare Act to make room for other laws that are protective of animals, whether they be state anti-cruelty laws or the Endangered Species Act. I want to sort of ask you about the outer limits of your argument. This is a sort of common question that you might get from the court, but sort of explore the outer limits, and maybe for Delcy, when it comes to this idea of captive animals, would your approach mean that there are some species or all species that are listed that are captive that you think should not be captive because mere captivity would constitute harassment, whether it's for Lolita or for all captive endangered species? And then for Ani, the same idea of the outer limits of your approach. Are you advocating for the notion that the AWA is completely preemptive and that there are no parts of the AWA or no sort of scenarios that you could see that should have supremacy when it's possibly conflicting with a state law?
I'll go ahead and go first. I think the concept that the Fish and Wildlife had when they promulgated that regulation was probably going in the right direction. I don't think there's certainly scientists who argue that there are certain species who we just cannot keep humanely in captivity. Polar bears and elephants come to mind because they're such wide-ranging animals. But I think in this context, it would have to be a case-by-case analysis, and you would have to look at the conditions of that particular animal and whether their behavior-based needs were being met, whether husbandry was rising to the level of adequate protection for the animals.
I do believe that the strongest argument for preemption is conflict preemption, although that was only made by one court. Most courts were arguing for field preemption, which I think there's absolutely no support for. It's hard for me to honestly envision a situation where there would be conflict preemption if we're looking at statutes similar to the ones that currently exist. And those being statutes that both protect animals directly, prohibiting cruelty, abuse, torture, neglect, and statutes that protect animals indirectly but seek to target animal cruelty by creating the right to sue for other grievances like waste of taxpayer dollars. So it's hard for me to envision a situation where I would see supremacy based on the current statutes that states have promulgated.
So let me ask Delcy about you were talking about captive animals and how it would have to be a sort of case-by-case basis. Do you have any sort of what would, in an ideal world, how would those standards be developed? Would they be developed through the battle of the experts in a case? And how does that, in your mind, give sufficient notice to the regulated community?
Yeah, I mean, just like any other issue that we resolve through litigation, I think it probably would be through a battle of experts. And that is what has happened in these cases. You have experts relying on the generally accepted scientific literature about what these animals are needed. That said, I mean, they get notice first through a notice letter. The Endangered Species Act requires that you file a 60-day notice letter before filing suit, and part of the purposes of that is to allow someone to come into compliance. I also think there would be, it's very, very expensive to bring these lawsuits. You need to have Article 3 standing, so you need to have an ongoing injury that would be remedied through the suit. So I think there are limiting factors. It's not like we're suddenly going to see a million lawsuits. And even the suits that we have seen have really focused on the worst of the worst. So the groups that are spending resources on this are not going to start going after the AZA zoos who keep animals in, under pretty relatively rigorous guidelines. So I think we'll still see it at the margins, and I think the generally accepted literature about what animals will need will provide guidance on that.
And so to follow up on that, are there generally accepted, the AZA, for example, would you advocate for potentially adopting those standards as the standard, or prescribing even further standards, having the agencies promulgate rules on those?
I mean, given sort of along the lines of what we were talking about on the last panel, I think it's pretty burdensome to ask Fish and Wildlife to promulgate rules about what every species needs. And science is evolving so quickly that it would also be difficult to keep those up to date. So I think, again, in a case-by-case basis, you would have experts who come in and can draw on the very most recent science, and yes, certainly be informed by what AZA standards require, and perhaps by what the USDA requires under the Animal Welfare Act. But I don't think it's a regulatory approach necessarily that would be best.
And to follow up, Ani, on the same lines in terms of notice, state anti-cruelty laws, and many of them are broader than the humane handling provisions of the USDA promulgates. Do you think, sort of being very clear that the AWA is not preemptive of state laws, is there any kind of issue with notice, I guess, to the regulated community about specifically the standards that should apply in research facilities, for example, when you have broader state cruelty laws?
I assume that there could be some issues of notice, but we're held accountable to what the law says, and ignorance of the law typically is not an excuse for lack of compliance at any level. So I guess it's an argument that I wouldn't necessarily find compelling.
So we have some questions from the audience. For Delcy, can you talk about the extent to which USDA enforcement or the lack thereof has played a role in these specific cases?
Yeah, I think that's been really important. I think that was most noticeable in the Cherokee Bear Zoo case, but played a role in all of the cases. And so in the Cherokee Bear Zoo case, we saw the court very clearly saying, USDA has tolerated this under the Animal Welfare Act. Therefore, we're not going to do anything about that. In the other cases, in Lolita, it wasn't stated so clearly, but at issue was certainly the fact that the USDA has said recently that her tank is acceptable size, which is strongly disputed, as Naomi mentioned earlier. And on the flip side, in the Cricket Hollow Zoo case, it played a role that the USDA had, in fact, cited Cricket Hollow repeatedly for violations. And those inspection reports showing those citations played a role in informing the court.
And another question from the audience. Can you talk about I think you alluded to this in your comments initially, but can you talk more about how the captive breeding program and holding these animals in captivity increases the trafficking in the wild and actually has a negative effect for the preservation of the species?
Yeah, so I mean, there are a lot of different ways, and I can't get into all of the science on it, but I mean, for example, the USDA, in a recent tiger listing update that it did, recognized that captive breeding of tigers could be feeding the demand for tiger parts, which are used for traditional Chinese medicine. The pet industry is a big part of it. So as I said, when people see animals and see people interacting with them or have an opportunity, it does create demand. People want to be able to have those animals for themselves. So you see animals being sold in the pet trade, and some of those animals are being pulled out of the wild. You also have a lot of inbreeding, as Anna mentioned in her presentation. So you have people breeding different subspecies of tigers. So we have the vast majority of tigers in this country now are generic tigers. The U.S. Fish and Wildlife has said they have no conservation value whatsoever. These animals can never be released into the wild. They can never be used as a breeding program that would help with conservation. And then even beyond that, we see people breeding tigers with lions, and then you have low-ligers and tigons, and it's just completely messing up the gene pool of these animals.
Another question from the audience. Can you, and I think this applies to you, Ani, but probably to both of you, in terms of research, what does the role of the local state prosecutors, and how much information do you see that they actually have about research facilities? And do you think that sort of a lack of comprehensive regulation at the state level is informing their decision to either not prosecute at the state level, or it's informing the courts to sort of interpret the state law as not covering research facilities?
Well, I think it is part of the reason I termed it a myth. It is a bit puzzling, actually, how prosecutors could think that there is preemption for the reasons that I outlined. And In the cases that I've discussed with people at animal charities across the country, and also with some prosecutors, though I have not done an empirical study, and one thing I actually would be really interested in input from the audience on is whether that would be useful information to have in litigating cruelty cases, why it is people aren't bringing these cases. Because to answer the question directly, I think the information's out there. So what's happening? I don't know. I mean, prosecutors are smart people. Are they really not understanding the preemption issue? I find that hard to believe. Or is there something else motivating their unresponsiveness, and maybe they're using the preemption argument as an excuse? I honestly don't know. I haven't done the empirical work. It really is a mystery. Limited resources obviously are an issue for litigating cases. I can't tell you how often someone has said to me, well, we could prosecute this animal cruelty case, or we could prosecute this child abuse case. And it's almost as if it's presented as an either or, as opposed to we need to be dealing with both at the same time. So that's about the best answer I can give to that.
And I'll just add, I don't know if the question was getting at this, but as far as access to information about what's going on with these animals, I think that's actually one of the most useful parts of the Animal Welfare Act. It provides us with a huge amount of information. All of the inspection reports are posted online. You can pull down information about any licensed facility and what their compliance has been, and details about what their violations have been, which animals were involved. You can get photos of those violations through the Freedom of Information Act in many instances. And as Ani mentioned, the Animal Welfare Act mandates that the USDA cooperate with state and local facilities. So in that sense, I think they have no excuse for claiming not to know what's going on within their jurisdiction at these facilities.
So can you talk a little bit about whether you see a distinction between researchers and the other regulated community in the AWA? I think for both of your presentations, Ani, you focused on research, but I'm also curious, Delcy, as to whether or not there is any application for the definition of harassment in the research context.
Do you want me to go first? Yeah, so harassment definitely applies to research animals. There are numerous research facilities that actually have, I didn't get into this, but the Endangered Species Act does allow for permits to engage in otherwise prohibited activity and provide certain conditions under which permits can be issued. And so anyone engaging in invasive research on a protected species needs to have one of those permits. So just to give you one example, Emory, Yerkes at Emory has an Endangered Species Act permit to engage in invasive research on mangabees, which are a severely endangered primate. And so I think, the Fish and Wildlife Service has been absolutely upfront. The law is clear that there is, it also applies to research. And in fact, one of the exceptions for a permit is for scientific research. You can obtain a permit for scientific research, but that research needs to be done to further conservation in the wild. So, mere research to further human interests is not a basis for a permit.
And yes, I think the preemption problem applies, unfortunately, across the board. It's not limited to laboratory settings, although that's where we have the most, although scant case law. And that can be seen in the fights over state puppy mill laws, anti-puppy mill laws, where people are arguing that these laws should be preempted by the Animal Welfare Act for licensed breeders. So the idea that if you hold a license, that's sufficient, and the state cruelty protections wouldn't apply to you. Even within the research setting, there are a lot of state statutes, 36, I believe, that have exemptions for research. And so we see state legislatures buying into the preemption type arguments too. And so I think that's important to mention as well. And that certainly applies in research and exhibited animals and in the pet dealer domain.
So we have a question from the audience that touches on this question of research, and also harkens back to my initial question about the outer limits of your analysis. And that is, the question mentions that the state of Maryland has a bill that was introduced in the last session that would have prohibited research in dogs and cats. Do you think that kind of sort of banning of an entire class of activity, what's your view about the preemptive effect of the AWA on that?
So, I mean, obviously there would need to be a, conflict preemption analysis there. That's, I think, could be viewed as being in conflict with the spirit of the Animal Welfare Act, and certainly this idea of, researchers holding the key to the laboratory door. On the other hand, states certainly can promulgate stronger standards, and there would have to be cooperation between the state and federal government. I think if something like that actually were to pass, which I find highly unlikely, I think there could be arguments that the state law shouldn't be preempted. Now, whether those politically would hold, I doubt it.
Another question we have from the audience, and Delcy, you talked about this, is standing, and kind of what can be done to address the issue. I think we're going to be talking about this tomorrow, but what can be done to address the issue of standing for citizen suits, and who tends to currently bring these cases for both of you?
Yeah, so we will have a presentation on this tomorrow, so I don't want to intrude too much on that. But, so Article 3 standing is part of our Constitution, so we're not going to get around that. And that requires that the person bringing suit suffer an injury that can be redressed by the lawsuit, as I said before. That said, Cass Sunstein, who's here at Harvard Law School, has said, and courts have agreed, there's nothing stopping the legislature from putting a statute in place that would allow an animal to be a plaintiff in a suit, and the animal then would be the one suffering an injury. So it's really a question of legislation giving a cause of action to the parties who are actually being harmed here. And I think I'll leave it at that, because we will have a whole discussion about it.
And that's also relevant to what I discussed, of course.
And sorry, I'll just add, very relevant to Ani's discussion, is that states don't have the same limits, some states at least, that we have in the federal government. So that's another reason why the state causes of action can be so valuable.
So because you mentioned legislation, let me ask you a very broad question. If you had a magic wand and could have any sort of legislative fix to address the specific problem that you've both identified, or regulatory fix, where would you make it in the statute or the regulations?
Well, I think, if the USDA, APHIS were to issue a policy statement or regulations clarifying that the AWA does not preempt, state laws targeting anti-cruelty, I think that would certainly resolve the matter.
And I would certainly get rid of the regulatory exception in the harass regulatory definition. I think it was intended to allay confusion. I think it's actually wrought more confusion. And so I would certainly agree with HSUS's petition to get rid of that. I don't think we need to do anything further legislatively on this issue. I think the law is clear. The agencies that are responsible acknowledge that captive animals are included under the Act's protection. Certainly it couldn't help to have the agency reiterate, it couldn't hurt, sorry, to have the agency reiterate that point, but I certainly don't think it's necessary. I probably would get at this standing citizen suit issue if I truly had a magic wand.
So on the legislative fix question, Ani, you mentioned in your presentation that there are provisions already in the AWA that expressly permit, or at least I think are cognizant of the fact that states have laws in this area. Is the placement of that provision, as I recall it, in the provision that talks about the humane handling standards, it's not sort of in a more general place in the statute? Do you think have you noticed that that's a cause of concern, or has that been identified by the courts as a reason for limiting the preemptive effect?
It has not been an argument in any of the cases. I actually think it's a benefit that it is where it is, in the sense that it's clear it's a response to, it's under the heading of standards, and it says, Part A, here are all the A1, here are all the AWA standards, and second part, Part A, here's the clear provision that states have the ability to promulgate their own legislation addressing cruelty. So it seems like it's in my view, pretty well placed, actually.
So another question from the audience is about, and the question gets at the fact that the AWA and the ESA were both passed at times and close in time in history, and do we need more citizen knowledge and awareness and involvement in this area? Sort of what can we do?
Yes, I mean, along the lines of what was discussed on the other panel, there's a lot that we can do without legislative fixes. We can not support facilities that are engaging in these behaviors. All three of the facilities that I talked about are supported by the pocketbooks of the people who go there. So if these places learn, and I think we are having increased public awareness and opposition to these sorts of treatments of animals, they're going to go away just by virtue of the marketplace. So I think that's something that all of us can do is, of course, not support these, but also educate those in your circles so that, I mean, I don't think the people who support these places have bad intentions. They are ignorant, and there's a lot of work to make them ignorant. So try and combat that.
I actually think the role of society is really important in this. I mean, the law can only go so far. Going back to the delicate balance argument to support AWA preemption, I mean, it really sort of touches on what I think is, the fundamental issue, which is that we struggle with the balance of, using animals, to promote certain human causes and protecting their welfare. And many would say that's even a false conflict because we put them in the position to begin with. So no matter where you fall out on that argument or on that, on the spectrum of answering that question, that's kind of a key question. And so I think it's not surprising. We see that rhetoric coming up in all of these contexts. Because, yes, that's what we're struggling with as humans, as a society. And so that's the problem we create in the court. That's the problem that the courts have now created in the preemption context. It's not surprising to me. So I think it's just as important to have these try to invoke these social changes sometimes, or even more important, maybe, than the legal changes.
When you talk about other things we can do, and particularly in the state context, pressing back on state law and giving more weight to the state laws, I'm curious, Ani, for you, in preemption, the touchstone of preemption is congressional intent, but I'm curious about what the backdrop of the law was before the AWA in terms of the states. I know that the states have a long history of having these older anti-cruelty statutes, but have any of them, so does the practice of the states, as far as you're aware, indicate that they were regulating this area more and then sort of step back?
I honestly haven't looked extensively into the prosecutions that occurred, before the act, but I haven't read anything indicating that they were greater by any means, but that could be for other reasons, and I really haven't done any empirical look at that.
Okay, I think we have time for this last question from the audience. So the audience member notes that the strongest arguments against the use of animals in entertainment and research is that it's not necessary, but that the Animal Welfare Act doesn't really give weight to those types of arguments. So the questioner is asking, shouldn't we just put our efforts on state laws, the enforcement of the state cruelty laws, and devote all of the resources to that area?
I think we need to use a multi-pronged approach. So if we're focusing on one-off cruelty prosecutions, that's going to take a really, really long time to get all of these issues. I mean, with the cub petting, for example, as Anna said, there's dozens and dozens of facilities, and I don't think it's realistic from a resource perspective to expect the states to prosecute all of these. So I think that's certainly important. I think the state and local laws banning some of the worst practices are hugely important. I don't think they would be preempted. But I think we also, because we're talking about such large numbers of animals, we also need to be looking at the federal regulatory level.
Oh, I was just thinking, I didn't state the obvious with respect to your last question, which is that, of course, pre-Animal Welfare Act, we're talking, before 1966. So I'm sure that also would have affected prosecution.
All right, well, thank you very much.
Thank you.